What is self-defense law? Self-defense law is the set of legal rules that allows a person to use force, including deadly force, when they reasonably believe it is necessary to repel an imminent and unlawful threat of serious harm. In plain terms, it is the doctrine that says you do not have to be a victim if someone is about to kill you or gravely injure you. That is the clean definition. The intrigue begins when this protection collides with messy facts, unreliable witnesses, and expanding statutory shields such as castle doctrines and stand-your-ground provisions. Then the headline practically writes itself. Why do self-defense laws seem to let murderers walk free? A quick origin story helps. Self-defense descends from English common law, which long recognized that the state's monopoly on force breaks down at the doorway of immediate danger. Over centuries, courts refined three core constraints: imminence, necessity, and proportionality. Imminence means the threat must be pressing, not speculative. Necessity requires that defensive force be genuinely needed, not merely convenient. Proportionality demands that the response roughly match the threat. Later, modern systems added the reasonableness test. Would a reasonable person in the same circumstances share the defender's belief about the danger and the need to use that level of force? So how does a doctrine so bounded acquire such a bloody reputation? Start with burdens of proof. In many United States jurisdictions, once a defendant produces some evidence of self-defense, the prosecution must disprove self-defense beyond a reasonable doubt. That is not a loophole. It is a reflection of the presumption of innocence. But in close cases with scant video, conflicting testimony, or absent weapons, situations common to fast, chaotic confrontations, the state's burden can be very hard to meet. Jurors do not have to be certain the defendant was justified. They need only harbor a reasonable doubt that he was not. The result can be an acquittal that, to grieving families, looks indistinguishable from a murderer walking free. Next, consider the duty to retreat. Traditional common law imposed a limited duty to withdraw, if safely possible, before resorting to deadly force in public spaces. Castle doctrine carved an exception in the home. No one must flee their own dwelling. Stand-your-ground statutes widen that exception, eliminating any duty to retreat in many public settings so long as the defender is lawfully present. This expansion changes trials in quiet but consequential ways. Prosecutors can no longer argue persuasively that the defendant should have stepped back or driven away. Jurors are instructed that withdrawal was not legally required. That narrows the narrative battlefield to the defendant's perception of danger, which is inherently subjective and often unverifiable. Reasonableness should be the anchor, but it too is slippery. Courts typically apply an objective test flavored by the defender's circumstances: size, age, prior threats, knowledge of the aggressor, and the dynamics of the moment. Yet objective does not mean omniscient. If a defender claims he saw a glint that looked like a knife, and the scene was dark and chaotic, a jury might find his fear reasonable even if no knife is ever recovered. Add in the split-second nature of many confrontations and the law's tolerance for human error under extreme stress, and you start to see how the legal shield can look. From the outside, like armor for the guilty. There are more doctrinal twists. The initial aggressor rule bars self-defense if you provoke the fight, unless you clearly withdraw and communicate that retreat. Imperfect self-defense, recognized in some places, acknowledges a genuine but unreasonable belief in the need for deadly force. It does not acquit, but it can reduce murder to manslaughter. And then there are presumptions. Some castle-style laws presume a reasonable fear when force is used against a home invader. Presumptions are rebuttable, but they tilt the scales at the outset, shaping how jurors hear the story. Let's ground this with examples. Imagine a midnight home intrusion. The homeowner fires, believing the intruder is armed. Under castle doctrine and a presumption of reasonable fear, the law treats the homeowner's decision as presumptively justified. If the intruder turns out to have been unarmed, the optics are tragic, but the legal analysis still favors the defender because the question is the reasonableness of the belief in the moment, not the perfect accuracy of hindsight. Now picture a parking lot shouting match that escalates. There is a shove, a flash of something metallic, a shot, and panic. Witnesses disagree. No weapon is recovered. The defender testifies to a genuine fear of being stabbed. With no duty to retreat and a high burden on the state to disprove self-defense, a jury may doubt the prosecution's case. To a public reading the headline the next day, it can look like the law blessed a killing. In reality, the law applied its most conservative principle. Do not convict when the evidence leaves a reasonable doubt. A third scenario involves imperfect self-defense. A driver confronts a trespasser, misreads a gesture as a draw for a gun, and fires. A court may find his belief sincere but unreasonable, stripping away full justification while rejecting the label of murder. To families, that downgrade can feel like exoneration by another name, yet it reflects the law's calibrated moral judgment. Culpable? Yes. The worst form of homicide? No. Does this mean self-defense laws are broken? Not necessarily. They aim to prevent two distinct injustices: punishing the innocent who acted to save a life and greenlighting private vigilantism. The difficulty is that facts at the edge are murky, and modern statutory trends sometimes push those edges outward. As stand-your-ground rules proliferated, academics and advocates debated whether they embolden escalation, particularly when implicit biases shape perceptions of threat. Courts have responded by emphasizing that mere fear is not enough. The fear must be both honest and reasonable, the danger imminent, the response proportionate, and the defendant free of unlawful provocation. Those phrases are not empty. They are the legal brakes. History offers curiosities. The castle metaphor is medieval, but the modern brand name, Stand Your Ground, is contemporary, a political slogan wrapped around an old retreat doctrine debate. Another curiosity is evidentiary. In many cases, the only surviving narrator is the shooter. The law does not award that survivor a victory, but the absence of contrary proof often makes the state's job hard. Finally, the doctrine's reach is not uniform. Some jurisdictions retain a robust duty to retreat, others confine presumptions narrowly. Still others demand heightened scrutiny when the defender helped create the peril. Above, I leave you more videos so you can keep learning law. Remember to leave us a like and subscribe.